Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Today, we have a lot of Lori Vallow news. Why? Because they had a hearing today, and we were actually able to watch it. And I watched Sins of My Mother on Netflix last night, and I will give you my thoughts. Then we have the judge in the Nikolas Cruz case. To say that she blew her top would probably be an understatement. Oh, right, and that R. Kelly guy, guilty. 2 cases of the devil made me do it, and then finally our dumb criminal of the day. Let's talk about it. Good day, aficionados. You know the drill. Subscribe if you haven't, like if you do, hit that bell so that you receive notifications. Leave me a comment below about what we discussed today. And remember, you can listen to us on any of your favorite podcasting apps. Just simply type in Crime Talk with Scott Reich. We pop up and you can take us anywhere. All right, let's go ahead and get to the docket. September 15th of 2022. Let's open the record. So a motions hearing was held today to determine whether cameras will continue to be allowed during the court proceedings for Lori Vallow and Chad Daybell as it relates to all their hearings. As you may recall, Lori Vallow's attorney, Jim Archibald and John Thomas, filed a motion last month to ban all cameras from the courtroom in future proceedings because Vallow's trial, which is set to begin in January, they think that it would, in fact, prejudice their client because everybody wants to focus on the client and their reactions. Well, guess what? That's the same thing jurors do. Why do you think the public shouldn't be able to look at her as well? Well, prosecutor Rob Wood and Lindsay Blake filed a response to the motion in support of the camera ban. Are you kidding me? Are you kidding me? Lori Vallow appeared in court. She was wearing a little pink blouse and some heels. That's right, heels and some curled hair. See, now where I've practiced, I don't care who you are. When you're in custody, you show up in your little jail outfit unless and until it's actually trial. Now, Vallow was seen smiling, but became noticeably more tame with her emotions and facial expressions than in the previous hearing, which was kind of the big kerfuffle based upon the motion filed by the defense saying no cameras because, well, they catch our client laughing and smirking. We don't like that. So, like I said, following that hearing, they filed a motion to ban cameras. Now, Mr. Archibald argued by allowing cameras in the courtroom, his clients will have to prove her innocence instead of the state having to prove her guilty. Scott Reich's response to that, hogwash. The burden always remains with the prosecution, and cameras are just there to observe. That's it. The defense and the prosecution noted that, well, they believe in the constitutional right of the freedom of the press. They don't believe that it includes broadcast. It's, quote, we let the media police themselves, and what did they do? They put microphones on our tables and cameras right in front of our faces, said Mr. Archibald, referring to the August hearing where 2 cameras were used and a microphone were placed on the tables. Both sides stated that the media exposure is impeding Lori Vallow's right to a fair trial. I don't think so. You can watch today's hearing, you can watch today's argument. But Mr. Archibald complains that 30 minutes was zoomed in on my client, and what was the purpose? Mr. Archibald argued. She didn't make an argument. All she did was whisper to her lawyers. There was no point. 33 local, state, and national media agencies joined in the opposing of the motion. Steve Wright, the attorney for the media, argued that the news organizations followed a court order during the last hearing and did not take any unauthorized steps while recording the broadcast at all. It is regrettable that counsel feels misled and that they didn't notice the microphones, but they were approved first and foremost along with the cameras, said Mr. Wright. There is no significant difference in telling this court that this courtroom should be open, but only to people who physically want to come and sit in the courtroom, because if it broadcasts to other people, her rights are now jeopardized. Now, Mr. Boyce interrupted Mr. Wright to disagree, saying at some point, if there is so much saturation that it presents a presumption of guilt, I think that's entirely possible in that case. And I'll tell you, I'm quite concerned that that's happening here. Judge Boyce also noted that he does not know the members of the media, who they were employed by, or who pays them, so he cannot personally guarantee that they will always follow the rules, although there's been no circumstances thus far where the media has not followed courtroom protocol in this case. Now, the attorney for all the news agencies, Mr. Wright, said that pretrial publicity was not going away and that the motion was an inappropriately extreme response to actions that were approved by the court. Now, Judge Boyce ended his conversation with Mr. Wright by stating, "I'm very concerned that this goes beyond access, that this goes to creating a financial enterprise that revolves around this case." The judge did not immediately make a ruling and said a written decision will be forthcoming. Mr. Larry Woodcock, J.J. Vallow's grandfather, stated that he doesn't want cameras banned from the courtroom. He said, quote, "To me, the issue is not the cameras or audio. The issue is Lori playing to the camera. Absolutely, cameras should remain. I want my family, our friends, and the people that follow us worldwide, they deserve to know what happened." A bigger concern to the Woodcocks is that J.J. and Tylee's bodies still have not been released by the police or released by the district attorney. He said, quote, "All I want to do is bury the kids. Come on, it's been 3 years," said Mr. Woodcock. "J.J. is in a vault. He's in a freezer. Judge, let us have them so that we can bury them." In addition to the motion to ban cameras, there was another motion that would allow Lori Vallow to appear in street clothes. Now, although she's appeared in street clothes in previous hearings, according to her counsel, it was never in writing. And her attorneys argued that having her appear in street clothes helps her right to a fair trial. The prosecution has no opposition, and Judge Boyce granted that motion. Another motion was filed in July to incorporate state and federal constitutional grounds in support of future motions for Lori Vallow. Her attorneys argue that all of her constitutional arguments need to be preserved in case the jury eventually comes back with a guilty verdict and she is sentenced to the death penalty, which, let's face it, would probably never be imposed because it would be in litigation for the next several decades. All right. First, I really hope the judge does not ban cameras. There was nothing inappropriate at all in regards to the cameras focusing on Lori Vallow. And if the judge is that concerned about that, fine. Then just say you can only focus on the overall courtroom, which is the judge and the witnesses. But people want to see the defendant's reactions. It's normal. That's what juries do when they're looking at judging credibility. Okay? Do they react? Do they not? You can't get much from it. And reality of it is, the jury's not supposed to consider that. And the jury is presumed to follow the jury instructions. And they can only consider legal and competent evidence that comes forth from witnesses and legal and competent evidence that is admitted through the proper foundation and admitted into evidence. So I hope the judge doesn't do that. I'm a little concerned by some of his comments, basically saying that it's going to create a financial gain to broadcast this. Well, that's what Court TV and other, that's what we do. Let's just cut to the chase. We want it to be broadcast, and I'd be sitting here and we want to be monetized. Let's get for real. I'm not going to pull punches on that. Everybody is looking to make a buck on that. That's just reality. Okay. But it can be done, and it's a trial that should be open to the public given the significant publicity that it has already seen. Which brings me to my next point. Do I blame the defense for raising this issue? No. They're doing everything they can for their client, Lori Vallow. It's a tough road to hoe, not only for Lori Vallow, but for Chad Daybell. Okay? It's bad. They're doing everything they can to basically hope this kind of will go away, but it's not going to go away. And why is that? Talk about pretrial publicity. Last night, I watched it, so you don't necessarily have to if you don't want to, but I watched the Netflix 3-part series, Sins of My Mother. This is the story of Lori Vallow's son, Colby, telling how he's come to realize that his mother is guilty. Justin Loom, who we've been on his show before, and he talks about kind of the facts and the timeline of all the events. I thought it was actually pretty well done. But did it provide anything new whatsoever? No, I think the only thing that I wasn't aware of was that Lori Vallow's mother originally supported her daughter, and well, let's just say she thinks she's guilty too. All right. But it was a good movie in the sense that it provided a good overview and will only make this trial make people more interested in watching the trial. Okay. And it did refresh me because it's been a while. Because if you've been watching Crime Talk for any time, we were one of the first to bring you this story when it started to break, and over time, and everything that was in that video, except for mom saying she's guilty, we've talked about. We've brought you the videos. We've brought you the testimony. There was nothing new there at all. But it did really give the picture of the conduct, the lies, and just the general diversion of answering any questions by loved ones from Lori Vallow. And the phone call where Lori's in custody and Chad says they're searching the property now. Oh, inside? No. Outside. Oh, doesn't look good. I wouldn't want the cameras there either to see when the prosecution starts piling on the evidence. And hopefully, if the prosecution over 3 years hasn't figured out how to tell this story to the jury, they watch this Netflix because they laid it out pretty well. Okay? Next on the docket, the Nikolas Cruz judge loses her mind. Well, not really, but she got upset. So the judge in the Parkland school shooter case, Nikolas Cruz, sentencing trial, raged against the attorneys and accused them of a lack of professionalism after the defense abruptly rested their case on Wednesday. Now, the stunned Judge Elizabeth Schur was caught off guard by the announcement, which caused her to pause before going off on the attorneys for wasting a day in court. Look at this video.
Your Honor?
Yes,
At this time, the defense rests, other than putting in our records.
we're not playing chess. I mean, will you please take the jury back in? Thank you. All right, go ahead and put in your records.
2B, Nikolas Cruz Henderson, episode 1 record.
Let me just stop. State, are you going to have anything ready for today?
No.
The defense last told us there was 80 witnesses.
We're waiting for 40 more witnesses.
I just want to say, this is the most uncalled for, unprofessional way to try a case. You all knew about this, and even if you didn't make your decision until this morning, to have 22 people plus all of this staff and every attorney march into court, be waiting as if it's some kind of game. Now I have to send them home. The state's not ready. They're not going to have a witness ready. We have another day wasted. I honestly have never experienced a level of unprofessionalism in my career. It's unbelievable.
So, Judge, if we had any pretrial matters, you asked us to be here at 9:15. We were here at 9:15 to discuss pretrial matters. I have been practicing in this county for 22 years.
You know what? I don't want to hear it. I don't want to hear
Well,
it.
Judge, you're insulting me on the record in front of my client, and I believe that I should be able to
Okay,
defend myself.
you can do that later. You can make your record later, but you've been insulting me the entire trial. So, blatantly, taking your headphones off, arguing with me, storming out, coming late intentionally if you don't like my rulings. So, quite frankly, this has been long overdue. So please be seated. You can receive the evidence. I will receive the evidence. And then you can put whatever you want on the record at the end.
She says, "We're not playing chess here." Oh, Judge, yes, we are. She said, "I just want to say this is the most uncalled for, most unprofessional way to try the case." Well, the defense attorney, Melissa McNeil, had previously told the judge that they would be calling 80 witnesses, but suddenly rested at the beginning of Wednesday's court session after calling only 25. McNeil attempted to explain her decision, but the judge cut her off. The 12-member jury and 10 alternates were not in the courtroom for the little bit of exchange there. And the sudden announcement also meant that the prosecution were not ready to begin their rebuttal case, which is now scheduled to begin on September 27th. Closing arguments and deliberations are set to take place the week of October 10th. Okay? Now, the defense team, when they rested, The judge then questioned Mr. Cruz and prosecutors about a list of defense witnesses who didn't testify to make sure that he, Mr. Cruz, was okay with that, and those witnesses not taking the stand. As you may recall, Cruz pled guilty last October to murdering 14 students and 3 staff members on February 14th of 28 at the Parkland Marjorie Stoneman Douglas High School. His trial, now ending its 2nd month, is only to determine whether he is sentenced to death or life without parole. Now, like I said, his attorneys rested. They told the judge under oath that he agreed with their decisions. And since the defense rested their case without warning, the state prosecutors weren't ready to begin their rebuttal case. The prosecutors, you saw, threw up his hands and asked if they could begin, and with a nervous laugh, and said, "No, we can't." He said, "We're waiting for 40 more defense witnesses." The judge also accused Cruz's attorney of being inconsiderate to all involved, but especially the jurors for wasting their trip to the court. "I've never experienced such a level of unprofessionalism in my career." Well, Ms. McNeil countered angrily and said, "Judge, you're insulting me on the record in front of my client," before the judge told her to stop and said, "You can make your record a little bit later," basically accusing her of saying, "You don't like my decisions, you show up late. You're rude, disrespectful to me." Her exact words were, "You've been insulting me the entire trial," Schur barked at defense counsel McNeil, "blatantly taking your headphones off, arguing with me, storming out, coming late intentionally if you don't like my ruling. So quite frankly, this has been long overdue. Please be seated." Now, let's just be clear, ladies and gentlemen. The defense, you have to endorse all of your witnesses. I've endorsed cases where I got 15 witnesses ready to go, Your Honor. And guess what? Something changes. Something takes place in the prosecution's case in chief. And I say, we're not going to do it. We're not going to call these witnesses. Yes, it is a bit of a chess match, Judge. Get for real if you think it's not, for goodness sakes. They're trying to save that young man's life, no matter how horrible of the things that he has pled guilty to. It's their job to do that. And guess what? If it means inconveniencing a juror, 22 of them, guess what? They're going to inconvenience a juror every moment of that day if they can, if it means they're going to do something to help their client. Bottom line, okay? Now, frankly, if you want to talk about unprofessional conduct, the judge going on the record like that, not good, because it shows that maybe she's a little, prejudiced towards the defense. And if there's a questions as to her rulings, guess what? It's going to come back and bite her. That's why judges are supposed to exercise a certain decorum in the courtroom, a judicial temperament, so that they don't get upset. So it doesn't look like they're leaning to one side or not. And if the judge really thought somebody was acting out and misbehaving, then you hold them in contempt. You don't build up until the end of it. And guess what? My experience is every time somebody ended short, the jurors were happy, because that means they actually got to go do their jobs and get home early. And the prosecutor needs another week to get their witnesses together. Are you kidding me? Judge should have told them, have your witnesses here ready to go by tomorrow morning. Let's move this case along. We're not delaying it. I don't know. Sure, maybe the defense attorney could have said, "Hey, Judge, I'm going to just let you know we've decided to shorten our thing just for scheduling purposes." But they have no obligation to do that whatsoever, and the judge knows that. So I got to back the defense attorneys up on that one. All right, real quick. Remember that guy, R. Kelly? Hopefully we're getting soon to not hearing anything about him. Well, he was found guilty of 6 of the 13 charges that he faced in that federal trial in Illinois. The jury came back guilty. The jury convicted him of child pornography counts, but he was found not guilty of 7 others, including charges of conspiracy and enticement. As you may recall, he was facing child pornography charges, and prosecutors also accused him of concealing video evidence from his infamous 2008 trial and threatening witnesses. Now, sentencing for Mr. Kelly, he's looking at anywhere between 10 to 90 years, which also means that can be concurrent or consecutive, more than likely consecutive, with his case in New York. Next on the docket, the devil made me do it. An Arkansas man sawed off his own leg while his 5-year-old daughter was in the house after ranting he was both Jesus Christ and Satan and threatening to twist his wife's head off. Shannon Cox was charged with first-degree endangering the welfare of a child, along with his wife, Sandy, who fled the home in fear but left their young daughter with her father, who proceeded to amputate his leg. Now, the affidavit describing the August 2nd incident in Boone County said police responded to reports of a man with a severed leg and arrived to find Mr. Cox lying in front of the residence naked and missing a portion of his right leg. Shannon told the deputy he had severed his leg with a chop saw, and upon entering the home, the officers discovered blood all over the walls and floors, with the leg in place still lying on the saw. Investigators found additional dangerous materials at the residence, including a white four-door car with a hood up, with a 20-pound propane cylinder laying on top of the battery, and an Arkansas driver's license belonging to Shannon Cox. The investigator also noted that there were ashes inside the vehicle and the rear passenger window was broken out. Now, Shannon was then airlifted to the Cox Medical Center south in Springfield, Missouri, while officers tracked down Sandy at a friend's house and asked her for an interview the following day. She claimed that on the day of the incident, her husband had been acting a little odd. Sandy told the police that Shannon had become increasingly aggressive towards her and claimed he was Satan before threatening to twist her head off. He continued to make verbal threats, forcing her to flee the residence, terrified that her husband was going to kill her. One problem: she left their 5-year-old daughter in the house with the unhinged Shannon, who thought he was obviously Jesus Christ and Satan at the both same time, and thought that it was a good idea to chop his leg off with a saw that was used for cutting wood. When asked why, she told police officers that she wasn't worried about her daughter. She just said she wasn't worried. Like I said, Shannon managed to lop off the limb with a rigid brand chop saw, which is usually used for cutting pieces of wood. When police interviewed the daughter after the incident, she confirmed that she was present when her father sawed off his leg, and the affidavit stated that the girl is still in some state of shock and would keep trying to steer her away from the conversation. The daughter is no longer under the care of her parents, thank goodness, and is currently under the care of the Arkansas court system. The married couple were released after posting their individual $10,000 bonds and will appear in court in October. Now, while Shannon has never had a felony charge against him, but it is unclear whether he had previously been accused of domestic violence, abuse, or charged of a misdemeanor. Hopefully, Shannon gets some help, either for some drug or some mental health issues, or a combination of both. Chopping off your own leg. I just can't imagine. You either A, must be on drugs, or you must either A, be on drugs, or B, completely crazy to do that on your own. I mean, isn't that going to hurt the next day? I mean, are you serious? Next, another teacher case. That's right, a probable cause affidavit sheds a little more light on how investigators put together a case against a former private Christian school teacher for allegedly twerking on a male student at prom. The court records indicate that there was more than just eyewitness accounts of the alleged April 22 prom incident at the Point of Grace Christian School. Julie Nizey Hoover had a phone call after the incident with another student's mother. As law enforcement listened in and admitted she let the devil in at the prom, according to the affidavit. The devil made her do it. The devil. It's like the church lady that Dana Carver used to be. Who made you do it? The devil. During that call, Julie was asked about prom, and she stated that she let the devil in. The call appears to have been made in connection with an investigation into a separate case Hoover faces for allegedly sexting a male student. The twerking affidavit dates back to June 7th, which reportedly 5 days after authorities learned of the sexting allegation and 1 day before Hoover was arrested in that case. Investigators allegedly found that Hoover and a teen began exchanging messages back in March of 2022 and continued to do so through April of 2022. Authorities have not specified whether the two cases involved the same students. Hoover's initial arrest, a mother reported police that the The suspect had exchanged sexually explicit text messages with her son, an 18-year-old high school senior. Hoover allegedly had plans to sneak the student into her home while her husband was at work. But Hoover was arrested again in the first week of September, that time on charges of contributing to delinquency of a minor who was 17 at the time and soliciting or engaging in sexual conduct against a student by an authority figure. I just got to add that to my repertoire of defenses for cases. The devil made me do it. Next, our dumb criminal of the day. A Florida man was arrested and accused of using an excavator to crush a woman's truck after she failed to find enough money to buy drugs, according to police. Now, according to the Charlotte County Sheriff's Office, Richard Hamilton of Inglewood, Florida, was laughing hysterically as he used an excavator bucket to smash the woman's Chevrolet Silverado pickup truck on Sunday. Deputies said the incident began on Saturday night when Hamilton drove the woman to several gas stations around town, all while demanding she find money for drugs. Hamilton became increasingly agitated after the woman failed to come up with enough money. A day later, September 11th, Hamilton and the woman drove to his place of work at Kelly Stone Sand and Boulder. Hamilton got out of the woman's pickup truck and took the keys with him. When the woman told him her phone had died, calling several people in an effort to borrow money, Hamilton physically assaulted her, according to the police. Sometime later, Mr. Hamilton was seen laughing hysterically and smashing the pickup truck using the bucket on the excavator. Wow, all that effort. He could have got his own money to go get his own drugs. Are you kidding me? You can't make this stuff up, ladies and gentlemen. Mr. Hamilton, congratulations. You are our dumb criminal of the day. Congratulations, you made it. You've been catapulted to the top of our dumb criminals for the week. You've made it. All right, thanks for watching. Hope to see you next time on Crime Talk.